Hello and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'm going to talk about some updated guidance regarding gag clauses. As you may recall, the Consolidated Appropriations Act of 2021 prohibits group health plans from entering into any agreement with a third-party administrator, a healthcare provider, a network of providers, or other service providers that directly or indirectly restrict the plan from making provider-specific cost or quality of care information or data available to participants, beneficiaries, plan enrollees, plan sponsors, or referring healthcare providers, or electronically accessing de-identified claims and encounter information for data for each participant, beneficiary, or enrollee in the plan or coverage consistent with applicable privacy regulations upon request, or sharing such information or data described, directing such data to be shared with a business associate consistent with applicable privacy regulations. So that's kind of a mouthful, but the gist of it is it's part of the Consolidated Appropriations Act effort to expand transparency with respect to health and welfare benefit plans, group health plans in particular. And not only are TPAs and providers not allowed to have these provisions in their contracts, but plan sponsors have to attest to the government, to the Department of the Treasury, Department of Labor, and Health and Human Services on an annual basis that their third-party administrator agreements do not contain prohibited gag clauses. And this attestation is done online and is due by December 31 of each year. It's kind of a burden for a plan sponsor, for an employer, to even know whether there is a gag clause in their TPA Administrative Services Agreement. These agreements do not have in bold print prohibited gag clause. So it takes some understanding of what this definition of a gag clause means, and then a careful review of the agreements to make sure that the prohibited gag clauses are not in the agreements. So to that end, the Department of Labor recently issued guidance trying to flesh out exactly examples of some gag clauses that might not be as obvious. The first one is, in the FAQ guidance, is that a downstream agreement between a TPA and a provider network, for example, that prohibits sharing of information with the plan sponsor is a gag clause. So for example, if there's a contract between a TPA and a provider network that prohibits the TPA from sharing cost information with a plan or a plan sponsor, that would prevent the plan, if it can't receive the information, from providing that information to participants or to a business associate. And so that downstream agreement is viewed as a prohibited gag clause. This means that not only does a plan sponsor have to pay attention to its own administrative services agreement with a TPA, but it also needs to make sure the TPA hasn't entered into a downstream gag clause with a network of providers or with healthcare providers. And so I think this requires in the agreement, in the administrative services agreement, a provision that says that the TPA has not entered into such downstream agreements. So that's an example of a gag clause prohibition that wasn't really obvious from the definition of a gag clause in the Consolidated Appropriations Act. A little more obvious, the FAQ guidance explains that if an agreement only permits the plan sponsor or the plan to share claims data at the discretion of the TPA, basically with the TPA's permission, that is a prohibited gag clause. The agreement cannot restrict disclosures to only disclosures that the TPA consents to making. So that is a prohibited gag clause. Additionally, any limitation on the scope, scale, or frequency of electronic access to de-identified claims and encounter information or data is prohibited to the extent that it imposes an unreasonable limit on the ability of a plan to access the information or data upon request. And the FAQs provide some example of prohibited restrictions. So a limit on access to statistically significant or minimum necessary number of de-identified claims is prohibited. Limiting the scope of the access to the data to specific narrow purposes is prohibited. Unreasonably limiting the frequency of claims reviews, such as you can only review claims once per year, that would be a prohibited gag clause, limiting the number and types of de-identified claims that a plan or issuer may access, restricting the data elements of a de-identified claim that a plan or issuer may access, and providing access to de-identified claims data only on the TPA or service provider's physical premises. So these restrictions, these limitations on disclosures, even though the disclosure is allowed, over unrealistic limitations on receiving the information and having the information disclosed is also a prohibited gag clause. So what does this mean for plan sponsors? Well, first, it requires a review of your administrative services agreement. Those agreements have been reviewed, hopefully, to identify gag clauses. But now that we have a little bit more guidance from the Department of Labor, I think it requires a fresh review to make sure that we don't have some of these not so obvious gag clauses in our agreements. And certainly, if there is a renewal of an agreement or a plan sponsor hires a new third-party administrator, those agreements need to be carefully reviewed to ensure compliance with the Consolidated Appropriations Act. So that'll wrap up this discussion of gag clause guidance. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.
This podcast contains general, condensed summaries of actual legal matters, statutes, and opinions for informational and educational purposes only. It is not meant to be and should not be construed as legal advice. Listeners with particular needs on specific issues should retain the services of competent counsel. For more information, please visit our website at www.williamsmullen.com or contact any member of our team.